I'm so pleased to have a few minutes to talk media law with one of my buddies, Rachel Fugate, who is one of the founding partners of the Shulman Fugate law firm down in Tampa that specializes in representing news media clients. Rachel has her law degree from Florida State and her undergrad degree from the University of Florida. And she's been a very active participant in the American Bar Association's communication and media law activities, and had some direct personal connection to the Hulk Hogan Gawker case that we talk about in the class, and I'm going to force her to relive that experience. So Rachel, thanks for taking time to join us. Can you kind of just first start off by talking about your practice a little bit? How'd you get into this line of work? What does a day in life look like, or a week in life look like for a partner at Shulman Fugate?
Mhm. Well, I had known that I had wanted to do media law or some sort of law dealing with the First Amendment from law school, but it's pretty hard to break into the area because there's just not a lot of jobs in the media law sector. So I actually, started out doing criminal defense work and happened, to get a great opportunity at one of the bigger firms, Holland and Knight, doing media law practice a few years out of that. And so since about 1999, all I've done is media law work, and left Holland and Knight, went to a smaller boutique media law firm. And then in 2017, left that and started my own media law practice with Deanna Schulman, Schulman Fugate. And although we do a little bit of intellectual property work and other business litigation, I would say 90% of our practice is media law. And it really is almost 100% of what I do. And we represent the media in all aspects of what we do. So we do kind of pre-broadcast, pre-publication review. We'll review the stories before they're published, investigative pieces to kind of flag issues, privacy issues or defamation issues to make sure that the stories are just as safe as can be. We'll help journalists with their news gathering issues, access to information, public records, access to courts. We fight subpoenas for reporters and journalists. And then ultimately, when they do get sued for defamation or invasion of privacy, we'll represent the media companies in that aspect of as well. So kind of a full service firm for all of your media law needs.
Well, the subject that I wanted to focus in on for this conversation is privacy law and some of the privacy law issues that arise in gathering and publishing news. Sometimes when you're in the news business, you have to make some difficult judgment calls about publicizing information that's embarrassing or gives away something confidential about somebody, a health condition, mental health, addiction, marital problems. What are some of the considerations that go into making that decision, and what are some of the legal principles that would apply?
Mm. One of the first things we'll look at is the status of the plaintiff, and it's not really as much of a concern in privacy as opposed to defamation, but I do think it still is relevant. Is this a public official or a public figure or just a private person? Certainly public officials, public figures, there's more scrutiny of their conduct. So sometimes embarrassing or private information about them, can be more warranted depending on the circumstance than a private individual. So that is one thing that kind of goes, overall into the analysis. And then the second thing is, what is the information and its relation to the news story? So, even if it's embarrassing or personal, if it's, necessary to tell the story or relevant to the story, if it helps the reader kind of fully understand or the viewer fully understand what's going on, then it's fair game. So, I look at both of those things, but more so than kind of the status of the person is, what is the connection to the news story? Are we putting this in there just because it's gratuitous and it, might be kind of sexy to the story? Or, is it really necessary to tell that story, especially if you're dealing something with, highly private or personal information? And that kind of goes into line with in an invasion of privacy, a private facts case, there's a defense to that if the information is newsworthy. So you look to, what is the connection to the story? And does it kind of help tell that story?
Yeah, so medical history or healthcare impairment is a classic example of that, right? The fact that your next door neighbor has had a stroke is not of any interest to anybody, but the fact that a
Right.
justice of the Florida Supreme Court has had a stroke may be because it may impair that person's ability to function in their job, right?
Absolutely, certainly. So that's like you're looking at both. Kind of there, the status of the person comes into account, and really their role is kind of what makes that information newsworthy because they have a little more, there's more oversight. You're looking at what that person is doing more, and if they have had a stroke and they're impaired, I think that's certainly something that the public's going to be concerned about. But it doesn't always have to be kind of the you know something of that import. There was a case where a football player, kind of, sprained or broke a finger. That's medical information, but it can be for entertainment purposes too. So the courts aren't going to look at, like, news and your traditional mainstream media. They're not going to kind of make those judgment calls on, is this something the justice would read? It's kind of, entertainment can be news too. So is a segment of the population interested in that, even if maybe I wouldn't be? And if so, even if it is very offensive, it's protected.
Yeah, no, that's a really important point because that's how, frankly, gossip publications are
Yeah,
able to exist and not be sued out of existence,
right,
right? Is that the courts don't just look at public importance, they also look at public
right.
interest or public concern. And,
Yep.
right, Brad and Jen's divorce is a matter of public interest, although not really a matter of public importance.
Right, exactly. But they're going to look at that. Is it a public concern? Is a segment of the population interested in it and concerned about it? Whether I would be, that isn't, that's not the test. And you really don't want your courts making that kind of a judgment call on it anyway. And one of the Florida Supreme Court even said that, the exception is so broad that it nearly swallows the tort. And I think rightfully so, because you don't want your courts coming in and making those kind of like editorial, like, well, you know what, I don't like this news story. I don't really think it was important enough, so you didn't need to tell it. You don't want the courts making those types of editorial decisions.
Yeah. So a lot of the law of privacy and the law of defamation grew up in the paper and ink days, and we're not in those days anymore. Have online publishing and social media, legally speaking, changed anything about privacy law, or do all the same principles apply? And even if the same legal principles apply, do you think there's been a cultural change or a cultural shift which might factor as a litigator into, say, how you would assess the risk of the case as it's going to the jury?
Sure. Um, I mean, I think, the same legal principles are still there, but I do think with social media these days, and almost anybody is a publisher, and the availability of information, that it does al- almost make just about anything a matter of public concern. You can go and find it on Twitter, you can find it on Facebook, and um, it can be it, it it can be difficult to take um, the laws that did, develop, back with the print, and newspapers. And I do think juries and courts have a problem applying those today, especially with juries in the context of a new electronic age where everything is so available. Um, I think there are times that it leaves just, I think jurors especially think that things maybe just aren't right because it is so available, and they look at the internet and the availability of things, and it's hard to apply those old tests with a newspaper where it's not, there for everybody to see every day for the rest of your life. It's a newspaper. You have to go to the archives to get it. Or um, I think that it's just something that judges and juries struggle with when they're presented with that, even though the legal test still remains the same.
Yeah, it's fascinating. I don't know that very many of these cases have made their way into court yet, but you sort of
Right,
think about this concept of like micro celebrities that we have now, right? There are people who have a fleeting and perhaps very narrowly niched degree of fame, that they're a YouTuber.
right,
They have a huge social media following. Maybe they appeared on one episode of a reality show. And so
Mhm.
does that make them somebody whose personal
Right.
life is a matter of public interest and concern? I don't know that the courts have yet kind of figured out where that line is or should be.
Mhm. No, I don't think they have, and I think juries especially struggle with where that line is.
Yeah. I mean, do you think that could, there's a sense that social media has made exhibitionists out of all of us, and that we're now oversharing things about our personal lives that we only used to tell our best friends. But on the other hand, people still have kind of a profound sense of being intruded upon when somebody, you'll hear somebody has been creeping on my social media page, right? A page that I
Yeah,
set up to be viewable by the public, and someone has been creeping on it,
yeah.
and that causes me to feel invaded. And so people have not totally abandoned their bashfulness. They have not totally abandoned the idea that there is a zone of privacy
Mhm.
surrounding their affairs. So how does that factor into the mentality of a jury that's being asked to assess an invasion of privacy?
It's just it's really hard because I do think also too with a lot of times social media, there are things that you share and that you do that you wouldn't say to that person face to face. So I think a lot of people almost detach themselves from that social media kind of persona. But when they're having to deal with kind of the issues, as a juror or personally, I think it's almost a little bit of a different standard that they may use. I mean, we do share everything. I don't even know what privacy really is in this day and age. But I do think people kind of almost have a sense of detachment about me being on Twitter and tweeting something out. Um, but then yet, if the tables are turned and something is, if you unwittingly become in the limelight of one of these or something goes viral, or when you are sitting on a jury, I think people still think there is a lot more privacy there. It's a really hard thing when you have a privacy case to really account for that.
Yeah, no, it's fascinating, especially because the line of sort of what qualifies as publishable has been so diminished by the ease of online publishing. I mean, when you think
Right.
about a newspaper or a television station in the 1970s making a decision to devote some of their limited space to a news story, right? They would probably say, well, the fact that somebody who has had a very fleeting amount of fame by appearing on one episode of a television show got in a car accident or is getting a divorce or is in the hospital is not something that I'm going to devote my limited airtime or my limited news pages to. But there are no limits anymore, right? And so the
Right.
fact that some reality show contestant wrecked their car and is in the hospital might be something today that rises to the level of public concern.
Well, and also I think the stuff that what's difficult with the jury is that your jurors are not young, savvy, people that are, I mean, honestly, they are often just because of the makeup of a jury and people who can sit on them. They are, typically older. They may not be kind of the tech savvy people that you think of. And it's just an odd mix trying to, explain those things to to a bit of an older jury, especially in Florida, that just may not be that experienced with them.
Yeah, no, that's really, I hadn't thought about that, but imagine trying to explain an Instagram influencer to your grandmother, right?
Right, or 12 of your grandmothers. I mean, it can be difficult, and and kind of expecting them to understand kind of the shift in publications and privacy that has occurred over the past few decades.
Yeah. Well, let's talk specifically about the Hulk Hogan Gawker case. And can you
Yes.
talk about your own involvement in that case
Mhm.
and why you think it came out the way it did?
Sure. So there were lots of attorneys on that case. We were local counsel and worked with a great law firm out of DC, and it was why it came out that way. And I mean, there are a lot of things that ultimately went, into the trial, but I think the most important thing was um, what we've been talking about, that public concern defense. It's a matter of law. The courts are supposed to decide whether a publication constitutes a public concern. They're not traditionally left to the jury unless it's kind of a close call, some factual issue. So I think the courts are supposed to do that, because you want to, when it is a public disclosure of a private fact, you're dealing with something that is highly offensive. That's an element of it too. So, when you're dealing with the publication of something that is highly offensive, asking jurors to apply the public concern legal defense is tricky. And I think the courts realize that, and they want to take the emotion out of that. And you want courts to decide those issues without leaving it to kind of an emotional whim of a jury who might not care whether something is a public concern. If it's highly offensive, they're going to ding a defendant. And in this case, the trial court had granted a temporary injunction in the case prohibiting Gawker from publishing the video. And we appealed that to the second DCA. And even though the context was a little different, there's, just in the terms of temporary injunction, not the ultimate final issue of the case, the court did decide that the publication of this sex tape was a matter of public concern. It said that, Hulk Hogan throughout his entire life had given publicity to his sex life. He had specifically given publicity to this sex tape. There were some still shots out there of this sex tape. He had given interviews about it, sometimes disputing it or whatnot. So basically what the court said, when you take kind of the history of the publicity around his sex life in general, and the publicity that he had given specifically to this sex tape, that publication of, and it was an excerpt of the tape, along with some commentary. And again, whether it's offensive to you or your cup of tea, it is really not the point. There was some commentary, kind of what Gawker did. They were snarky. So they were providing some snarky commentary on Hulk Hogan's sex tape, and took out of a 30-minute long tape, about like a little over a minute and a half excerpt of it. And what the court basically said was, look, the story is clearly a matter of public concern, and so too is the publication of the tape. And we had a trial court who, even when we moved for summary judgment, basically just said, even with that ruling, there's a factual issue, so I'm going to let that go to the jury. So I think that's the problem that you have, but you have a jury who's going to be incensed, like, how dare they publish a sex tape? And I think that's why you want to take those decisions out of a juror's hand. We had already had a second DCA saying it was a matter of public concern. So, I mean, to me, that was the hardest thing of that case, is that we did have an appellate court already saying, on the very legal principle, you're right. And there were a lot of things in the trial too that we kind of, couldn't bring out. But you can always kind of Monday morning quarterback on a trial. But I just think at the end of this, Hulk Hogan was a local hero, and the jury clearly didn't like that Gawker from New York, who was snarky and arrogant, published, the excerpt of him having sex. And they didn't like it at all, and let it be known through their verdict.
Yeah, well, and this is one reason why, right, when you're a defense lawyer, your job is to keep that case out from in front of the jury, if at all possible, because it
Absolutely.
is possible for sort of emotions or personal biases to take over in that jury room. And you've just described the exact nightmare scenario. You've got a local defendant against an out-of-state a local plaintiff against an out-of-state defendant that I'm sure is viewed as being a deep-pocketed media company.
Yeah.
And all the sympathies will be on one side.
Yeah, the perfect storm for a big verdict.
Yeah, no, that's nightmarish. Yeah, and
Yeah.
to underscore something you said at the outset, I mean, it is important that for a claim about the disclosure of private facts, that it really does have to be something that would be highly offensive to the reasonable person, right? So if the very same story showed Hulk Hogan being wheeled into the hospital with a broken leg in a wheelchair, that probably doesn't do it, right? I mean,
Right.
the guy's physical condition, he's a wrestler, so his physical condition is a matter of great interest. If he's like not ever going to be able to wrestle anymore because of the broken leg,
Yep.
we're all interested in that. And, you know, a broken leg is not something shameful or humiliating in any way.
Right.
So, yeah, he probably loses that case summarily, never gets to it.
Absolutely. So yeah, was it a matter of you know, I mean, it has to be highly offensive, or you don't even get there. So you're, you know, in all of these cases, you're dealing with something that is highly offensive.
Yeah, yeah. And of course, if you were drawing up a textbook case of what would be the kind of thing that people would not want to air outside of their closest circle of friends, it would probably be their sex life inside of a bedroom. So
yes, absolutely.
Yeah, no, it's a tough case for a lot of reasons. Well, what do you think are sort of the takeaways, larger picture from this case at the time it was decided? And of course, for people who've studied this, right, what eventually ends up happening is the case does get settled for an enormous amount of money, and the amount of money is so crushing that Gawker Media eventually has to declare bankruptcy, and it gets sold off for pieces and doesn't exist anymore. And so this was a bet the company case that ended in the company dissolving. So many people looked at that as a cautionary tale and said, well, this is going to send shockwaves and chills throughout the media industry, and people are going to be inhibited and chilled about airing sensitive material about the private lives of public figures. So what's your takeaway? It's been over 4 years now. What's your takeaway? Do you have any sense that there's been a lasting impact?
You know, I don't know that there has been a lasting legal impact. I think it is very easy to limit the Gawker case to the facts of the case, to the publication of excerpts of a sex tape. And the Hulk Hogan sex tape was kind of the end of that era anyway. There had been, you know, in the, you know, before the publication in the 2000, that was kind of a thing. You know, people publish sex tapes. It's what, you know, and this was kind of at the very end of that. So I don't know that there's going to be a huge lasting impact, because you can, and I think courts will rightfully, like, that was a unique situation to try to limit it to the facts of the case. But to me, I think there is a possibility for that, because what concerns me is that you can have something that is, everybody agreed, even the plaintiff agreed, that the story, the commentary about the sex tape was a matter of public concern. So my concern from that then is that you can have courts saying, even though it's a matter of public concern, you went too far in how you told the story. So it's a matter of public concern, but you didn't need to include that photo, or you didn't need to include that video. You just went one step too far with that. And that's what we don't want our courts to do. You know, the whole point of public concern is, if it's a matter of public concern, it doesn't matter what the court would do, whether it went too far, you know, it's protected. So if I'm writing a story about a matter of public concern, I should be able to show the video that shows that public concern, or the photos. So that's really my concern. If, you know, is there going to be, you know, some impact there? We had one case that kind of applied that, at least initially. It was a football player who I think was out for the playoffs or something. He had a broken hand, and the story about it was clearly a matter of public concern. And ESPN included, I don't know if it was something from his medical records,
Yeah,
like
it was
showing
a medical record, right?
Yeah, so it's showing that, and the court said, yeah, well, the story's public concern, but you didn't need to include the medical record. So again, that to me is the problem if you start kind of going down that road, because then your courts are acting as editors, or your juries are acting as editors. It's not enough anymore that it's a matter of public concern, because, you know, it's like, well, you can only do the very minimum, you know, of the public concern. If you go too far with that, then it, you know, you somehow lose the protections. And that's my fear. You know, we haven't seen a lot of that since then, but that is my fear about where it could go.
Yeah, and I mean, that is an important point for people who have to defend the interests of the news media and publishers, is you want there to be a zone between, you made a bad editorial judgment call, versus you owe somebody hundreds of millions of dollars. There's got
Right.
to be a freedom to occasionally make a bad decision, right? To
Right.
occasionally make a not optimal decision, and the
Mhm.
daylight between non-optimal decision and we are going to put you out of business needs to be big enough, needs to be enough zone of comfort there that a publisher can on occasion push the boundaries and make a
Mhm.
difficult judgment call where they might go an inch or two over the line without an inch or
Right.
two over the line being the financial death penalty.
Right. Absolutely. And, and knowing that if it's a matter of public concern, I'm protected, and because it does make it hard to, where do you draw the line? And one of the seminal cases on that established the public concern defense, it was a story about a husband had held his wife hostage in a kind of the cops were outside, they had been called, he was holding his wife hostage and made her strip naked. She runs outside and gets away from him, and she runs up to the police with nothing but a dish towel, over her, and the newspaper captures that and they publish that, and the court said, no, that's a matter of public concern. It is highly offensive to publish that, but it's a matter of public concern. But imagine if you had said, well, no, you could have just told the story and described what happened. You didn't need the photo. So that's essentially what, happened in the Gawker case. You could have told the story, you could have explained what happened. That's all public concern, but you didn't need the video or the photo. And in today's world, especially with videos and photos, sometimes just telling it isn't enough. So that's where I struggle with in providing advice these days. And
Yeah,
and,
yeah. I
and the
mean,
other thing that's also just very offensive to me about Gawker is that it was basically funded by a billionaire for the sole purpose of putting Gawker out of business. And it wasn't just this suit, but there were lots of suits that were funded, again, for the sole purpose of doing that. And that to me is a little scary.
yeah, and by the way, right, this was not a fact that was in the evidence
Right.
at the time or in front of the jury at the time, but it
Yep.
came to be known later on. The
Yes.
Silicon Valley businessman who had a grudge against Gawker Media because of a different story entirely had put up the money for the attorneys for Hulk
Yep.
Hogan / Terry Bollea
Yes.
to bring the suit, and that Hogan, maybe left to his own devices, wasn't planning to bring it, that he brings it almost as a proxy for this Silicon Valley billionaire. So, yeah.
Well, and you never know, would it have been litigated the same, or could it have possibly settled it? You just don't know, ultimately how that impacted it. But again, when you do have kind of that private funding for the sole purpose of driving a publication out of business, it is concerning.
Yeah, and I wonder too, I mean, I don't know the answer to this, but you wonder if it would have factored into the jury's evaluation to say,
Right.
well, you can't have been that upset about this. You weren't planning to bring the lawsuit yourself until somebody showed up and offered you a free lawyer, right?
Mm-hmm. Yeah, and we don't know, if, would he have brought the suit without the free lawyer? I don't know. Would it have been litigated? It's just, there's a million questions that you have. And, I know legally this funding is permissible and juries don't get to hear about it. But, the other thing that was interesting, there was, initially in the claims that were brought, there was the private facts claim, there was an intentional infliction of emotional distress claim, and there was also a negligent infliction of emotional distress claim. That negligent infliction of emotional distress claim is what provided Gawker's insurance coverage.
Hmm.
But the plaintiffs dropped that. And so it left Gawker with no insurance coverage, which is something that is a little odd for a plaintiff to do, to drop a claim that provides insurance coverage. So there were a lot of things like that just, to me, it was just troubling that you could have that, again, undisclosed.
Yeah. Oh, and so for
solely
folks
to
who are not in the litigation business, right, just to understand how unusual that is, if you are a plaintiff's attorney and you're bringing a lawsuit, you want the
you
insurance
want
company
insurance.
to be in the lawsuit
Yes.
because they usually have more money than the person you're actually suing does.
Right.
And often they are the source of the payout that you're going to get at the end of the day. And so to
Yep.
strategically exclude the insurance company would give rise to some suspicion that your agenda was not really to get the maximum amount of money, but to make sure that you took all of the company's money and not their
You'd,
insurers' money.
right. Yes. And that's why at the end of this, with no insurance coverage, having paid the attorney's bills to get through trial, and then with the huge verdict, Gawker just wasn't able to post the bond to appeal the case. Whereas pretty confident that if we had gotten to the second DCA, they already indicated where they were going to that. So, was fairly confident that we would have had some success there.
Yeah, well, so much about this case is, I guess, thankfully a one-off. We don't see a lot of cases involving grown men who parade around in G-strings being caught on bedroom tapes that air in the news media. So hopefully this becomes a
Yes.
unique case that is limited to those facts and those facts only.
Yes, hopefully.
Well, thank you so much. This has been
Welcome.
such a treat to spend a few minutes talking to Rachel Fugate about her practice and about her involvement in this very memorable, for better or for worse, case. So hopefully better outcomes for you ahead. And thanks again for sharing your time, your expertise with us.
Thanks for having me.